It's a Thursday evening. Eleanor, a 71-year-old retired schoolteacher in Arizona, is sitting in her recliner watching the news. A headline scrolls across the bottom of her screen. Supreme Court rules 9-0. Millions of retirees affected. Her stomach drops. She thinks about her pension, the one her late husband worked 38 years to earn. She thinks about the small 401k she rolled over when she retired. She thinks about the grocery bill that keeps climbing every month. She picks up the phone and calls her daughter. "Did you see this? Are we going to lose our retirement money?" Then the phone rings again. A man with a polite voice tells her, "Ma'am, you're entitled to a payout from the Supreme Court settlement. We just need to verify your bank account." Eleanor's heart is pounding. She doesn't know what's true. She doesn't know what's a scam. She just knows she's scared. If you've heard about this 9-0 Supreme Court ruling and you've been worried sick about what it means for your retirement, please don't go anywhere. Because in the next few minutes, I'm going to tell you exactly what the court actually decided, who it really affects, and the one trap that could cost you thousands of dollars if you're not careful. I am Faria, a senior policy analyst here at Hidden Tax Homeowner. For years, I've been helping retirees just like you cut through the noise and understand what these big legal rulings actually mean for the money sitting in your pension and 401k. Today, I'm going to walk you through the real story behind this Supreme Court decision, using only the official ruling from supremecourt.gov, guidance from benefits.gov, and analysis from AARP. I'll explain it in plain English, the way I'd explain it to my own mother. And please stay with me until the very end. Because there is a hidden mistake I'm watching seniors make right now, today, in the wake of this ruling. A mistake that scammers are using to drain bank accounts. If you don't know what to look for, you could lose more than your retirement ever gained from this decision. Let me tell you about Harold. Harold is 69. He retired 3 years ago from a private engineering firm in Ohio. He worked there for 34 years. When he retired, he had a 401k worth about $340,000. To him, that was everything. That was his fishing trips with his grandsons. That was his property tax payments. That was the cushion that let him sleep at night. Harold is a careful man. He reads the news. He pays his bills. And one morning, he saw the same headline Eleanor saw. Supreme Court rules 9-0 in retirement case. A few days later, Harold's phone rang. A woman with a kind voice told him she was calling from a retirement recovery office. She said because of the Supreme Court ruling, Harold was entitled to a refund of $1,400 in retirement plan fees. All she needed was his bank routing number to deposit the funds. Harold hesitated. But she sounded so official. She mentioned the case name. She mentioned ERISA. She even mentioned Justice Sotomayor. He gave her the number. Within 6 hours, $11,800 was gone from his checking account, money that was supposed to last him through his 80s. Here's what breaks my heart about Harold's story. The ruling was real. The Supreme Court did decide a case that affects retirees, but the call he received had absolutely nothing to do with it. There is no settlement fund. There are no checks going out. And Harold, like millions of seniors right now, didn't know that. So let me tell you what the court actually decided. On April 17, 2025, the Supreme Court of the United States issued a unanimous 9-0 ruling in a case called Cunningham versus Cornell University. The opinion was written by Justice Sonia Sotomayor. The case was about a federal law called ERISA. That stands for the Employee Retirement Income Security Act of 1974. ERISA is the law that protects the retirement money sitting in 401k plans, 403b plans, and traditional company pensions. According to benefits.gov, ERISA covers approximately 150 million American workers and retirees. It protects more than $12 trillion in retirement savings. Now, ERISA has a rule. The rule says the people in charge of your retirement plan, called fiduciaries, are not allowed to make sweetheart deals with companies that profit off your retirement money. They cannot let your plan be charged unreasonable fees. They have to act, and I'm quoting the law here, solely in the interest of the participants and beneficiaries. But for years, big companies have been pushing back when retirees tried to sue over excessive fees or self-dealing. They argued that to even get into court, the retiree had to disprove every single one of 21 different exceptions buried in the law. 21. That's an impossible bar for an ordinary retiree. The Supreme Court, in a 9-0 unanimous ruling, said no. Justice Sotomayor wrote that retirees only have to show 3 simple things. 1, that the fiduciary caused the plan to engage in a transaction. 2, that the transaction involved providing services. 3, that it was between the plan and someone with an inside connection. That's it. The burden of proving the exceptions now sits squarely on the employer and the plan administrator, where it belongs. In plain English, this ruling makes it dramatically easier for retirees and current workers to hold their retirement plan accountable when fiduciaries cross the line. This is good news for you. But it is not the kind of good news that puts a check in your mailbox tomorrow. And that's the part the scammers are exploiting. Let me walk you through the traps. Please listen carefully. The first trap is believing this ruling automatically increases your monthly pension or your 401k balance. It does not. The decision changes the legal rules for lawsuits. It does not change benefit amounts, it does not change cost of living adjustments, and it does not change Social Security in any way. The second trap, and this is critical, is assuming this ruling has anything to do with Social Security. It does not. Social Security is governed by a completely different law called the Social Security Act, administered by SSA Gov. Cunningham only touches private employer retirement plans like 401ks, 403bs, and company pensions covered by ERISA. Government plans, church plans, and individual IRAs are generally not covered. The third trap is thinking you have unlimited time to do something about a fiduciary breach. Under ERISA, you generally have 6 years from the date of the violation, or 3 years from the moment you actually learned about it, whichever comes first. If fraud or concealment is involved, you have 6 years from the day you discover it. Miss those deadlines, and the door slams shut forever. The fourth trap is throwing away your annual fee disclosures. Every year, your plan is required by law to send you a document called a 404A, 5 fee disclosure. It lists every record-keeping fee, every investment expense, and every administrative cost taken out of your account. Most seniors glance at it and toss it in the trash. After this Supreme Court ruling, that piece of paper is the single most valuable document for spotting whether your plan is overcharging you. The fifth trap is mixing this case up with another one. In June 2025, the Supreme Court decided a different case called Stanley versus City of Sanford. That ruling was 8-1, and it was bad news for retirees with disabilities. It said the Americans with Disabilities Act does not protect retirees from discrimination in benefits granted after they leave their job. Cunningham helps you. Stanley limits a different protection. They are 2 different cases. Don't let anyone confuse you. And the sixth trap, the one that got Harold, is the settlement scam. There is no settlement fund from Cunningham. The case was sent back to the lower court for further proceedings. There are no checks. There are no payouts. The Consumer Financial Protection Bureau has issued repeated warnings that fake Supreme Court settlement calls are one of the fastest-growing elder fraud schemes in the country, with average losses between $5,000 and $50,000 per victim. Anyone who calls you, texts you, or emails you saying you're owed money from this Supreme Court ruling is committing a crime against you. Hang up. Delete the message. Do not, under any circumstances, give them your bank account, your Social Security number, or your Medicare number. Now let me give you the 3 exact actions you should take this week. Write these down. Step 1. Request your retirement plan documents. If you have a 401k, 403b, or pension from a private employer, you have a federal right under ERISA to ask for a free copy of your summary plan description, your annual report on Form 5500, your summary annual report, And your 404A are 5, fee disclosure. Send the request in writing to your plan administrator. The law gives them 30 days to respond, or they can be fined up to $110 per day. These documents will tell you exactly what fees are being taken from your account. Step 2. Call the Department of Labor for free help. The Employee Benefits Security Administration, called EBSA, is a federal agency whose entire job is to help workers and retirees understand and protect their retirement plan rights. The toll-free number is 1-866-444-3272. You can also visit askebsa.dol.gov. They will not charge you a penny. They will not sell you anything. They will simply answer your questions and help you file a complaint if your plan is breaking the rules. Step 3. Protect yourself from the settlement scams. Bookmark consumerfinance.gov in your browser. Tell your spouse, your children, and your friends that there is no Cunningham settlement fund. If anyone calls claiming you're owed money from a Supreme Court case, hang up immediately. Then report the scam at reportfraud.ftc.gov. You can also forward suspicious texts to 7726, which spells spam. Now here is the hidden mistake I promised you at the beginning. The mistake that quietly drains more retirement accounts than any scam call ever will. Most seniors believe their 401k or pension is being managed honestly because, well, it has to be, right? It's the law. But the truth is, the Department of Labor and the Government Accountability Office have documented for years that excessive fees inside retirement plans can quietly steal tens of thousands of dollars from a single retiree's account over the course of their working life. A fee that's just 1% higher than it should be on a $100,000 balance over 20 years can cost you roughly $28,000 in lost growth. That money doesn't show up missing. There's no alert, there's no letter, it just quietly disappears year after year. The Cunningham ruling matters because for the first time in years, it gives ordinary retirees a real fighting chance to challenge those hidden fees in court without being thrown out before the case even begins. But you only get that chance if you actually look at your plan documents, ask the right questions, and act before the statute of limitations runs out. So please, don't sit on this. Don't assume the lawyers will figure it out for you. Don't assume your former employer is watching out for you. Get your documents. Call EBSA. Talk to a fiduciary financial advisor if you can. And if something feels wrong, file a complaint. And please do not rely only on YouTube notifications for important updates like this one. The algorithm is unpredictable. Videos like this one get buried. Rules and rulings change quietly throughout the year, and the people who profit from your confusion are counting on you not knowing the difference. If you want to stay protected, go directly to supremecourt.gov for official rulings, benefits.gov for retirement plan rights, ssa.gov for Social Security updates, and aarp.org for trusted senior advocacy. Here at Hidden Tax Homeowner, my job is to make sure no rule, no ruling, and no scam catches you off guard. If this video helped clarify what this 9-0 decision really means, please share it with another retiree who might be just as worried as Eleanor and Harold were. You may save them from making a costly mistake this week. I'm Faria. Take care of yourself. Take care of the money you worked your whole life to earn, and I'll see you in the next one.